You are listening to Hillary Topper on Air. And now, here's your host, Hillary Topper.
Hello and welcome to Hillary Topper on Air. I'm your host, Hillary Topper, and I'm so glad you're with us today. Today's topic impacts every single one of us, but it's one that we often put off: estate planning. Many people think that once you have a will or a trust in place, you could set it aside and forget it. But life changes, and your estate plan should change with it. The question is, when? To help us navigate this crucial topic, we have a practitioner with us today. I'm thrilled to welcome Marie Elena Puma, an attorney with the Russo Law Group. With her extensive experience in estate planning and elder law, she is the perfect person to guide us. Today, we're going to discuss the key life events that should trigger a review of your estate plan, from marriage and divorce to new children or changes in your financial situation. We're going to find out why an outdated plan could be so problematic and what steps you should take to keep it current. So let's get started. Marie Elena, warm welcome to the show.
Thank you, Hillary. It's great to be here.
So first off, tell us a little bit about yourself and your background.
Okay. Obviously, I'm an attorney. I've been here at the Russo Law Group since, while I was in law school, and then I came on after I graduated. So I've been here since I graduated law school in 1991, and I was here as a summer associate prior to that. We're an elder law, special needs, estate planning, estate and trust administration law firm, and we have several locations on the island: Garden City, Lido Beach, Islandia. And we have clients from all over, from the city and from out east. So we're here to service Long Island and New York City. And it's a pleasure to be here. We're actually starting to celebrate our 40th anniversary of the firm.
Congratulations. That's awesome. So can you explain in simple terms what an estate plan is and why it's so important that everyone have one, not just the wealthy?
Yeah, it's a really good question because that's a common misconception. One of the biggest myths that we always hear about is that people delay estate planning because they think it's for the elderly. They think it's people who are wealthy. They think it's for people with complex assets, but it's really not. It's about people who want to be in control, not just control about what happens to their assets when they pass away, but people who want to be in control of their lives while they're here living. You know, who can make their medical decisions if they can't do so? Who can make their financial decisions? That's about the here and now. Who gets my assets at the end of the day is a whole nother issue, but that's what people think estate planning is. But there's so much more to it.
So it seems like some people, they create an estate plan and then they file it away for years. What's the biggest single risk of having an outdated plan?
Good question. An estate plan is fluid. It's not one and done. It should be reviewed every 3 to 5 years at a minimum, and immediately after any kind of life-changing event. And I don't know if later we'll talk about some of those things, but it could be marriage, death, remarriage, moving to another state, an estrangement with a family member or with a fiduciary. I mean, there are all things. Life is so fluid and things change. So that's a big danger about doing an estate plan and tucking it away. Obviously, there's also things like changes in the law in terms of, tax law changes and other, things that are relevant. So it's important to have an estate plan, but you can't just file it in a drawer.
Yeah, so during this question, answering this question, you alluded to marriage, right? So that's a big one. How should getting married prompt somebody to update their estate plan? And also, what happens if, God forbid they get divorced? What do they do?
Right. So let's start with the marriage part first. So if you
Okay.
get married, obviously, You may want to provide for your spouse now because you didn't have a spouse previously. But before doing that, you may want to enter into a prenuptial agreement in some way because, nowadays people are getting married a lot older than previously in prior generations. So in prior generations, people were getting married in their 20s. They didn't really have assets. They weren't working. They haven't accumulated an estate of their own yet. Now we see people getting married in their mid to late 30s, and they have assets.
Mhm.
And maybe other obligations, family members and things like that. So entering into a prenuptial agreement would make a lot of sense because you may want to distinguish between assets. So that's one of the reasons. Other things are there are things like right of election in New York State where it says you can never disinherit your spouse. You must always provide for your spouse at a minimum of the greater of $50,000 or one third of your net estate. And then there are certain assets that come in as testamentary substitutes, which you think maybe, well, I designated a beneficiary on this, so I can keep that away from my spouse. But that doesn't happen in New York. New York will claw that back because New York wants to make sure a spouse is protected and gets at least a minimum amount. So these are all things that could be considered. Some people waive that right of election in a prenuptial agreement, or sometimes in an estate plan, the husband and wife or the spouses, partners, whatever, they will actually execute waivers of a right of election at that time. So there are all types of things that have to be considered. Now, unfortunately, if the marriage doesn't survive, you need to update because you may have appointed your spouse in your legal documents as your fiduciary. You may have appointed your spouse as the beneficiary of certain assets. And although New York has some law, like for example with life estate, where a beneficiary designation to a spouse is revoked, you don't want to count on that. The life insurance company may pay it out directly to the person, not knowing that there was a divorce. So there are things that you have to be proactive about, and you just can't rely on, well, the law says, and hope that that happens.
So let's talk about changes in the family. So what about like birth of a child, a
Yeah.
grandchild, or even the passing of a beneficiary affecting the existing plan? What
Yeah.
happens then?
So all significant life-changing events, and again, you can't wait for the 3 to 5 years. If these things happen, you have to go see your counsel immediately. So you may have a new grandchild, and you may want to provide for that grandchild and not exclude that grandchild in your legal documents. God forbid, you may have a child who predeceases you, and maybe that child has children and you want to move those children up to receive your predeceased child share, their parents share. So you want to look at that. You may want to put things in the form of a trust, depending on maybe you have a birth, God forbid, of a grandchild with special needs, and you need to provide for that child in a special way. You don't want to exclude that grandchild, but you want to protect that grandchild. So those are important things. And then obviously, if somebody passes away, you don't want to provide for them. You don't want to have legal documents that say they inherit something because they predeceased you. You want to update your plan. Sometimes people, another way I see someone's passing as affecting an estate plan is because somebody may appoint that trusted person as their trustee, their executor, the agent under their power of attorney, their healthcare agent. And now that person is deceased, or maybe that person became incapacitated in some way. And you don't want to be in a situation where you don't have your documents in place because you don't have somebody at the helm. Remember, estate planning is all about being in control, because if you don't, it gives you the opportunity to say, this is who I want to leave my assets to. This is who I trust to administer my estate and my legacy. This is who during my lifetime I want to be able to make medical decisions and financial decisions for me if I can do so. These are the documents that I want to express my wishes about end of life decision making. If you don't have those documents in place, you're leaving it up to the state of New York to make those decisions for you. And why would you do that? Why would you let New York State say who gets your assets and who can be your fiduciary?
Absolutely. And then there's also issues where there's financial shifts, right? For
Mhm.
instance, somebody receives a large inheritance, or they sell a business, or their net worth changes significantly. Like, what happens then?
Yeah, I mean, now you may be falling into that misconception that you need complex assets to do estate planning. Well, that is not the only reason why you need estate planning, but it's certainly a reason to make sure you have an estate plan in place and updated. So here at the firm, we actually had clients who won the lottery.
Wow.
We've had clients who received significant inheritances, and you need to now start looking about maybe more complex estate planning, maybe estate planning that considers estate taxes, right? How do we now protect and preserve the assets to minimize tax exposure upon the passing? So there are all types of things that you have to consider at that point.
Thank you. That's great. So with are there changes in the law, either at the state or federal level, and that may require people to revisit their planning even before that 3 to 5 mark?
Yeah, I mean, obviously you have to always look at there could be changes in the laws for Medicaid eligibility.
Mm,
That's a whole different concept in estate tax planning. There are changes in the laws for estate tax planning. We are in a situation federally where we've never seen the exemption so high before, right? I mean, we're at $13.99 million that you can either give away or die and give away during your lifetime and at death. That's almost $14 million. A married couple can give almost $28 million before you have a federal estate tax,
wow.
which we've never seen before. When I first started practicing, it was 600,000 federally and $108,333 for New York.
Wow.
Imagine, we know what houses go like what they're valued at on Long Island.
Mm,
What
hmm.
what could you do with $108,000 back then, right? So now New York is not as generous, but way more generous than it had been in the past. So now we're up at about just under $7.2 million a person. So you're still being able to give $14.5 million before you have a New York estate tax as a couple. So,
Mm,
but you have to look at all these things, having the having those higher thresholds may make somebody more inclined to do more gifting during their lifetime, and there's something that's I don't want to go too deep into taxes, but I do want to mention something about the federal estate tax. There's something called portability, and New York doesn't have that. And portability is about if the first spouse doesn't use all of the exemption, you can elect to preserve that balance that wasn't used and give it to the second spouse to die. Okay. A lot of people say, well, first, let's say husband dies first and their assets were under $13.999 million for federal purposes, and the spouse says, no, I don't have to file, right? For my husband, he was below. That may not be the right decision in
mm,
all cases. You may still want to file to elect portability. So if there's 5 million that he didn't use, now that wife, the second spouse to die, has almost $19 million to use. And that's important. It goes along with your last question, which is what if they inherit something? What if they win the lottery? What if the assets just continue to appreciate the way real property is appreciating? By the time if that second spouse still has another 20, 30 years, that spouse may need that extra amount. Now, New York is not as gracious and doesn't allow you to elect portability for the unused portion, so you may want to make sure that you do gifting during lifetime to use that exemption amount. Or sometimes we do something called post-mortem estate tax planning through the use of a qualified disclaimer that allows the surviving spouse to give up what he or she may have inherited so that it goes down to a child and uses that exemption, right? So there's all kinds of planning that has to be done, but you don't want to miss those opportunities. So it's important after the death of the first spouse, that's another trigger. Go see your attorney to make sure there's something you need that you might be missing to update your estate plan.
Now I want to shift gears a little bit, and I want to talk about what happens if the relationship with a chosen executor or trustee sours. Is
Yeah.
that reason enough to get an update?
Absolutely. I mean, totally. Every time you ask me a question, one or two clients at a minimum pops into my head for each question. I'm like, yep, we had this. Yep, we have this. We had a client recently, a long-standing client, and when I met with him and we were reviewing the fiduciaries, he's like, what do you mean that he's a fiduciary? I haven't spoken to him in 15 years. We had a falling out. And I'm thinking, we need to update your documents. And this is a client that has been at the firm for, 30 years or whatever it is. Now, so there are successors in place. And I said, well, he's like, well, what happens if I don't update it? I said, well, he would have to resign and then you have a successor to step up. And then he's like, well, maybe he won't resign. I'm like, well, do you want
Mm-hmm.
him in control of your estate? Again, it goes back to it's all about being in control, right? Just being able to make the decisions for yourself. Who's going to make those decisions to protect your family members, right? In that case, that client didn't want to name his children as the fiduciaries. Ultimately, he made changes to do that. But, when he did those documents, his children, he felt weren't financially astute enough, maybe not mature enough, and now they were in their 40s. So,
Right.
maybe it was okay. And so
Yeah.
that's what he ended up doing. But, another thing I just want to mention, we talked about marriage, and we talked about divorce. But another key reason to update your estate plan is remarriage after the divorce, right? Because now you have blended families. And depending on where you are in your stage of life, if you have minor children or if you're older when you have that second marriage, but you want to do planning where you provide for your spouse, but maybe you each have children and you want to make sure that they're each provided for in a certain way. So you may put things in trust for the surviving spouse, like um, the house, for example, that they live in, the house continues for the surviving spouse, but upon passing, it goes to the children of that first spouse, or, that died. So very complicated things. A lot of times when we have remarriage situations, we want to do trusts. So, it's really important that you consider something like that as well.
So, how do you handle situations where a client's beneficiary choices might cause family conflict? For example, treating children unequally in a will. And I bet this happens a lot where there's maybe a
It does.
favorite, you know?
It does. And sometimes it's not just the favorite, sometimes it's a way of wanting to say thank you to a child who may have been more available to the parent, maybe because they were situated locally versus in another state, right? As we see, the children are spreading out across the country and sometimes even out of the country. And sometimes there's that more local child, or maybe even the child that lives out of state that comes in more often. Um, you know, there are many ways to look at it. It really depends on the overall family dynamics because sometimes the other children know what's happening and sometimes they don't. So I always want to make sure that that is what the client wants. I have to meet alone with that client, make sure the client is not being influenced in any way or there's any kind of
Mm,
coercion, to make sure that that's what that client wants. Often, I will, if there's any question about if it's an elderly person, I will make sure that I get a letter from their doctor to put into my file that says that they have the ability to make those decisions. I will also ask my client to write me a letter to
hmm,
tell me what they want, and then tell them to get it notarized so that I'm starting to build
good
a file.
idea.
Um, I also suggest that the client talks to her family and lets them know what is she doing. I have a client right now where that's exactly the situation, and the other children aren't happy about it, but the mother and father spoke to them and said, "This is what I'm doing," and we're going to provide for this two of these six children in a little greater way because they've been more available to help us as we got
Hmm.
older with our medical needs.
Hmm.
Like I said, the other four aren't thrilled about it, but they didn't learn about it after the parents died. They knew about
Right.
it. So you try to, be a little proactive, try to anticipate the problems, but from a family emotional perspective, but from the legal perspective, you got to make sure that you have a solid client who has the ability to make those decisions, that's not being influenced, and you try to document, to have that information available.
Hmm. Very interesting. I mean, there's just so many different
So many.
facets of this, right?
Yeah.
So let's talk a little bit about digital assets, because that's also something that comes up, right?
Yeah.
Social media accounts, cryptocurrency, online banking. How should these be incorporated into a modern estate plan?
Yeah, so this is such a good question. And again, the bells are ringing in my head about clients that I have these issues on right now. And those clients that I'm thinking about are clients that passed away and how their fiduciaries are addressing these issues in their estate. So as a component of the estate plan, as I said earlier, you need to have the documents that take care of your during your lifetime, for health and financial decisions, medical decisions. Then you have the documents that are addressed when you pass away. There's also this like component, what I'll call a digital estate plan, and that's part of your overall plan. And it also, like advanced directives, falls into while you're alive, and also falls into what happens when you pass away. Because while you're alive, you can become incapacitated, right? And that's the whole reason why you have advanced directives, right? For medical and healthcare decisions. And so if you have become incapacitated during your lifetime, how do you deal with your digital legacy, right? Your digital devices, your digital assets. So we start by saying that when you draft your power of attorney, when we draft your will, when we draft your trust, we have to specifically put provisions in that allow the agent under the power of attorney, the executor, the trustee to have the authority to handle digital assets, digital devices, right? And you mentioned what all those are. So one, it's important, but it's not always that easy, because
Mm,
when you have these digital assets, you're in a contract with a third party, right? Whether it's the financial institution, whether it's um, LinkedIn, Facebook, Instagram, whatever the social media account is, and they have their own rules, Apple, Google. And this is a situation I'm having right now with them. So one is I tell my clients to put an inventory together. Let your trusted people, your agents know where that inventory is kept if you don't feel comfortable giving it to them now. That inventory should list all of their digital assets. It should list all of their digital devices. It should include PIN numbers, passcodes, passwords, answers to the questions, those crazy questions that they ask. Keep it somewhere safe so that your trusted fiduciary has access. Because, like I said, the documents may say, I appoint so and so as my executor, and there's a whole provision about the digital part. But it's not always that easy when you're dealing with under the terms of the contract, because they're going to ask you for certain things. The obvious, if someone's passed away, they're going to ask you for a death certificate and letters testamentary if you were appointed executor. But they're also going to ask you about the accounts. They're going to ask you about the PINs, the passwords, the security questions, and you need to know that. The other comment is that besides preparing an inventory, is a lot of these companies have their own rules about if you become incapacitated or when you pass away, who can access your account. So Apple has a whole legacy thing. Google has, I think, what's called an inactive account manager. So you really should look at your devices, your all your devices and your assets, and speak to those companies individually and find out what you can do with them as well, because
mm,
that might be easier than trying to convince them that your fiduciary has that authorization. Even though they do in New York, when you deal with these contracts, it's very, very difficult. So I'm dealing with a situation now with that exact case where somebody passed away. We have an executor, and we're going to likely only be able to get a list of, in this one case, of the client's emails and activity the on the phone, and on her computer, but they will not give us the underlying content.
Mm,
So we can see that the person corresponded with Merrill Lynch, Bank of New York, blah, blah,
right.
blah, or, Hillary Topper, but no one's going to let you see what was that discussion. What was the
Mm,
underlying account? What was she talking to Hillary about? So it's difficult. So you have to make
that's,
sure that
yeah.
you try to get through whatever their individual systems require. Try to apply apply fill out those applications. Make sure you do their rules as well as having it in your legal documents. And then the other thing is, obviously, if something's really important, go back to paper. I know everybody's trying to save paper and all, but the situation that I had in this estate is we can't even figure out what the assets are because everything was done online. So,
Oh,
and there
wow.
were no paper statements being mailed
Mm,
anymore. So print something, even if it's like once a year at the end of the year, or the beginning of the year. Keep a file in your
mm,
house that has at least your statements, even if it's an income tax return, something, so that we can look at 1099s and see where the assets are. And then things like photographs and videos and those types of things, always download them, put them on a UPS drive, have a hard something, so that
yeah.
you don't lose it, because sometimes it's really sad that you can't get you can't get access to these things after
Yeah,
someone passes away.
totally.
Yeah. So it's something that we didn't have to think about 35 years
I
ago when I started
abs
practicing.
absolutely. It's totally changed. So, if you were to give our listeners one piece of actionable advice today to ensure their estate planning stays current and effective, what would that be?
Oh, I would I don't know if I could just give one piece of advice, but I'm going to try to put it all together. Be aware, right? Know, see what's happening in your life. Be present. Say, is it time to meet with my attorney? The example I use here, and if I may, is to talk about a program we offer at the law firm. Would that be
Sure, of
okay?
course.
So we do this for our clients. So we don't, all the people say 3 to 5 years, life-changing event, and yes, that's true. But in our world here at the firm, we want to have a contact with our clients at least once a year. So when we do an estate plan for our client, we also offer a program called the Peace of Mind Program. And that Peace of Mind Program has many benefits so that the client can reach out to us throughout the year when these life-changing events occur. But also within that program is an annual meeting, so that we are looking at those documents with the client at least once a year to make sure that they're updated. So that's my advice. A client maintenance program. If you're going to do your estate plan, talk to your attorney about what options they may have available so that you can check in with them at least once a year. So
That's
that's
great.
that's my piece of advice on that.
That's great. For the Peace of Mind program.
Peace of Mind Program. Yes, that's my
Yeah, absolutely. Okay, and finally, how can people get in touch with you to learn more about you, the firm?
Yeah, well, obviously, we have a website, bjrussolaw.com, and it's a very, very robust website. We have blogs on it, we have video clips, we have articles, all kinds of information about the services, things that you should be thinking about. We have questionnaires on there, so you can easily hop onto the website. There's a wealth of information there, and then obviously you could always call the firm. And our general number is 516-683-1717. And, we love to be a resource to people. And if we can help you, we will certainly help you. If it's something that we can't help you with, we will do our best to get you to somebody who can help you.
That's awesome. Thank you so much, Marie Elena, for being on the show.
Thank you. My pleasure.
This show was produced by Hillary Topper and sponsored by the Russo Law Group, Long Island's signature elder law, estate planning, and special needs law firm. For more information, visit vjrussolaw.com. And PlayTry, your multi-sport specialist for all your triathlon needs. They have so many opportunities, including franchising. If you love the sport of triathlon, check out playtry.com and learn more about opportunities, or if you want to shop there, check them out. They've got great prices and they've got amazing customer service.